A very happy Wednesday to you and welcome to our Elville webinar series. Today's topic is trustee selection and how to choose the right one for you, presented by our one and only and very own managing principal and lead attorney, Stephen Elville. I'm Jeff Stauffer, Community Relations Director with the firm, and I'll be your moderator today. And we have a few housekeeping items as we have some new attendees today, so welcome as always. We encourage your general questions throughout the presentation, so don't be shy. We'll pause periodically throughout to address them. And your questions always add a lot of value to the presentation, so thank you in advance. And this morning by email, I did send you the presentation slides so you can reference them that Steve will be talking about if you want to take notes on them. They're also available in the section marked handouts on your screen to download at this time. And we have several professionals on today's presentation too. Thanks for being here. As always, most can receive 1.5 continuing education hours for attending. So if I don't have that already, please send me your ID number or accreditation so I can submit your hours for approval and send certificates out later today. And everyone will also receive a post-webinar feedback email right after the presentation. So take just a couple minutes to share how we did today and offer us your feedback about the presentation. And we value all the comments that you have to share with us. And here at Elville & Associates, we always want to be a resource to your family and you for your planning needs. If you have a new need to address, old documents to update, or perhaps another matter, Steve and his team are always here to counsel and work with you through your situation. And consultations are always a great way to have your specific questions answered and have Steve and his team understand your situation and always offer solutions, which is very important, and a path forward for you. So I'd like to offer Steve and the firm a proper introduction before we get started very briefly. And as I've mentioned the last couple of times, what makes Elville & Associates different from all those other firms that you may have talked to in the past or worked with? And this may be very clear to you over the next hour or so. So you should be able to see my screen here. Elville & Associates, we've been in Columbia since 2010, founded by Steve Elville. We just opened up our brand new Rockville office, which we're very happy with just a few months ago, going real great down there. Several different practice areas that we offer here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection, which falls under the lines of elder law and estate planning. We have 9 attorneys, 12 staff members, and 3 locations. And our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at the firm. We do that in several different ways. 3 of them are through our planning processes with our clients. We have different programs and to suit all of our families and individuals. Anybody that comes to us, we have a way to help them out more than likely. Also through our educational webinars and workshops that we serve in the communities that we serve each year. And also by way of our accredited client care program. We're one of only a couple of firms in Maryland to have a client care program accredited through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind every day with every client here at the firm. And just a bit about Steve. His work as an attorney for the past 23 or 24 at this point years has been centered in elder law, special needs planning, and estate planning. A member of many different national membership and professional organizations, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, just to name a few. He works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. And Steve is a very seasoned speaker, if you haven't heard him present before, offering many webinars, workshops for businesses and their employees, presenting at conferences, and continuing education events each year. And lastly, Steve was named to the Maryland Super Lawyers list for a 9th time, an 8th consecutive year in 2024. So congratulations there, Steve. We'll see what 2025 brings. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization that he founded in 2014. I'm very fortunate to be a part of. If you want to learn more about the Elville Center and how we work each day to make a musical difference in the lives of children, as we say, especially as schools are getting back underway and all the needs are so great out there, please reach out to me, and I would love to share our story with you when we have a bit more time. But for today, we're going to talk about the very important topic of trustee selection. So Steve, I'm going to go ahead and make you the presenter here. Steve, this is a topic that I think you'll say is top of mind to many, many of our clients and prospective clients that come to talk to us.
I couldn't agree more, Jeff, and thank you for that wonderful introduction. I'm getting my screen up here. Let's see if I can be as tech savvy as you are. And let's see if I can get my slideshow started, and we'll actually begin.
It's good.
Well, good morning, and thank you again, Jeff. And really appreciate being with you this morning. It's a busy Wednesday morning wherever you are. I know you're very busy and have many places you could be today. It's my privilege to not only present this information, but to lead Elville and Associates and all of our attorneys and staff as they help us accomplish our mission of education and actually helping people solve problems through legal technical solutions, and also providing lots of counseling. And we know that we have special guests here today, so thank you for attending on such a beautiful day, although the heat is back. And others, for example, professionals and financial advisors, CPAs, insurance professionals, and others that may be on this webinar are the general public or past clients. So thank you very much for being here. I want you to be able to walk away with something substantive today. We're going to talk about some substantive bullet points. I'll give you a few preliminary comments, and we're going to be respectful of our time, of your time. We're going to begin on time here, and we're going to end on time, so you can be assured of that. We're also going to take your questions, as that may be our ability to do so. And anything we are talking about here today, as we will talk about in just a minute, is high-level education. It can't be construed as legal advice. But before I make my preliminary comments, I'm just going to say, Jeff, is that what those school buses were all about? I mean, school is back. Is that what I was seeing the other day?
And it's hard to believe that school is getting back. I'm pretty sure it's back in Howard County for my kids in Carroll County. Starting on Tuesday, it's back to the grind for them.
All right. Well, I'm telling you, it's that time of year. And one other thing, Jeff, before I begin, I'm a little upset that, the other day you had given us such beautiful weather, and now the heat is back. So I'm just don't understand why you did that. But
well,
anyway.
Steve, we're going to work on that. The next 4 days are going to be nice and cool. So I took care of it for you.
Oh, very good. Thank you so much, Jeff. All right. In all seriousness, now we're going to turn our attention to the material. And one of the things, as I always give webinars and have been privileged to do so many of them, sometimes I have different epiphanies that kind of come into my thought process before I give a webinar. One of those epiphanies this morning was just about how views have changed over the years about trustee selection. I remember when I was a young lawyer many years ago, and I, of course, was mentored by many older, seasoned attorneys and so forth. And I remember their attitudes towards independent trustees and the attitudes toward corporate type independent trustees, and the biases and how many negative thoughts about certain types of trustees, and how that has changed over the years. And now we see that trustee selection is arguably one of the most important things in estate planning if we are leaving further trusts for someone that needs our protection, someone that has special needs, whatever that may be, or for tax purposes or whatever that reason may be. And of course, there's many different types of trusts. And it's just amazing to me how the time has changed, maybe my views and maybe the views in our world as our world evolves. And all this to say that trustee selection is one of the most important things. Just like Jeff said, it's one of the most crucial things that we could be talking about today. And normally I am talking through these materials as you a broad trustee selection, which we're going to do again today. But one of the things I wanted to mention as we get started is maybe turning this a little bit askew for this particular presentation. We're going to talk about all of those normal conventional thought processes, but I also wanted to put this into perspective from a trustee's point of view. Not only do you need to be thinking about who will be your trustee and all of the traits and responsibilities of a good trustee, but when we think of a trustee from their perspective, like the person who agrees to step into this fiduciary role for you, remember that that person is taking on fiduciary responsibility. It's one thing to talk about, oh yes, that is an important thing to think about as we choose a trustee, but it's another thing to think about the weight of the fiduciary responsibility that this person has and making sure that you feel that they are up to it. That person has tax filing responsibilities and tax management responsibilities. There are investment responsibilities. There are possibilities that this person will not be able to live up to that, or that they didn't pay attention, they weren't diligent, and that could result in their removal as a trustee. So these are very negative things to kind of start out with, but just remember that the person you're thinking about selecting, or this organization or this independent person or family member, this person not only has to meet your criteria and your thought processes, but they are actually taking on the weight of a lot of fiduciary responsibility, and we have to think about how will they be able to carry that out. So just a couple of things to think about as we get started here. All right, we're definitely not giving legal advice here, but you can enter into an attorney-client relationship. And when you do, even if you consult with an attorney, that is privileged information. If you're consulting with an attorney, sharing personal information, even if you don't become a client, that is privileged information. Just remember that today, this is very high-level educational material and is not an attorney-client relationship. All right, so let's get into this now. We're going to talk about what is a trustee and what are their responsibilities. And we just talked a little bit about that from the back end, from how it must feel on their end, but we're going to talk about the front end as well. We're going to talk about the types of trustees and what are the characteristics of these types of trustees? What are the advantages and disadvantages within this hour or so that we're spending together? We're going to talk about the perfect trustee and setting a very high benchmark. We want to shoot high when we are talking to our grandchildren, our children about life. You know, we're always talking to them about going for the gusto and shooting high. I want you to think about the same thing here as you're thinking about trustee selection. We want to shoot high. Why is trustee selection so important? Well, there are many different reasons. We talked about a few of those already. We're going to get into that. What is trustee succession? Not just trustee selection. What is trustee succession? And when you're designing a plan, why is this so difficult to think through? And this is an encouragement on our part to utilize the counseling that your attorney can provide, the tools, the thought processes, and actual planning processes that are in place. And that's an important thing, process. Because without a process, you're not going to be able to think clearly through some of these difficult issues. While some of you may already have some of these decisions already made, and you may just use this as a check, I guess, or a measurement or a test of your own thinking of your already pre-designed ideas. Let's get a feel for the trustee roles. What are trustee roles in wills and trusts? We're going to talk about that. And why would you consider appointing a corporate trustee or an independent trustee, right? And why should you be concerned about trustee risk? So let's talk about what a trustee is and what their responsibilities are. And again, just trying to keep you alert before we jump into the real meat of the material. I just want to check in with you for a moment. You're spending your valuable time with us on a Wednesday morning. I'm going to have the goal here this morning of really hitting hard, being redundant when I need to be, to drive home points that you will remember. This material that Jeff gave you, this PowerPoint, that's a tool for you. Okay, we've got a lot of distractions in our lives. Over the next 60 seconds, I want you to think about, why am I here this morning? Am I here to learn? Am I a professional here to get some continuing education? Am I a current trustee and I just want to learn more? Am I a person facing a certain situation? Let's start the timer. I'm just going to take 60 seconds, I promise, no more. Whether you have a tablet, a pad, your phone, whatever it may be, write it down, or at least form a mental image. Why am I here today? What is my goal for this material? What is it that I need out of this material? And am I having a current challenge right now with a trustee or thinking about a trustee or successor trustees? Do I have special needs children? Do I have children that need a trust or other relatives for their protection? Do I have someone in my life with a sobriety issue? Am I thinking clearly about my trustee selection, and have I gotten the proper counseling? Do I have family members, or now do I need to look outside of those family members for viable trustees? 10 more seconds. All right, we're going to stop right on 60 seconds. Let's get into what is a trustee and their responsibilities. Well, the role of a trustee, not surprisingly, is to administer the trust. Now, you'll notice that I just spoke to you like you're a fifth grader. And that's not usually what I do. I tend to get way above into the clouds. So today we're going to be really down into the fundamentals. I'm going to talk to you in all seriousness as if you were a fifth grader, and of course you're not. And I'm going to just hit you there. So the role of a trustee is to administer the trust, follow its terms and provisions. Would it be surprising to you to find out that many trustees have never read the trust that they are administering? Or maybe they read it once, but they've maybe gone back and referenced a couple of provisions, but they really don't know the trust inside and out. So that probably doesn't surprise you. But the trustee needs to follow the terms and provisions. Remember, they have a fiduciary responsibility. Okay, keep accurate records. Now, something just went off in my mind because somebody on this webinar said, what is a fiduciary? So let's stop there. A fiduciary is an agent under a power of attorney, a personal representative of a will, a trustee of a trust, okay? These are fiduciary roles. The person has a very high level of responsibility, and for those financial advisors that are on this webinar this morning, we know that many of you are fiduciaries. You are working in the best and highest interest of clients, and you have that responsibility. Okay, so the trustee is a fiduciary. They need to keep accurate records. How many trustees keep accurate records? Well, you can guess many trustees do not. They need to account to the beneficiary. Would it be surprising to you to know that beneficiaries have the right to information? They have the right to an accounting. So if we are a trustee or we're appointed a trustee, we need to make sure we're putting that person in a position that they can handle. That person needs to understand that they must account, right? And again, sometimes you might have to account on sudden notice. That person could be removed. They could be embarrassed. They could be removed and for a breach of fiduciary duty. So, role of a trustee is to account, keep accurate records, follow the terms and provisions, make distributions according to the terms and provisions of the trust, mandatory or discretionary, okay? For example, I have to distribute all income every 6 months or every 3 months, quarterly. That's a mandatory income provision versus a trustee could be told that they should or they can distribute income and principal on a discretionary basis. They have to make trust investments. So remember that we're going to talk about this a couple of times. The trustee is a fiduciary, so they have a duty to make sure they are hiring professionals. So if a trustee is not a professional investment advisor, they should not be investing the trust funds themselves because that's a breach of fiduciary duty. So not only do they need to hire an investment advisor, they need to get an investment policy statement, and we'll talk about that more, from the investment advisor saying, you have done your fiduciary duty. We are investing those assets as fiduciaries for you. Communicate with the beneficiary. So this is part of advocacy. This is part of communications and providing information. Ensuring all tax filings are complete. We talked about tax duties. And managing assets of the trust, taking into consideration the taxation of trust. Now that's beyond today's discussion, but the trustee has to hire professionals such as CPAs, lawyers, financial advisors to make sure that that person is being advised. That trustee is operating within their fiduciary duty, taking into consideration income tax and the taxation of trusts. Let's define some trust basics. So a trust is a relationship. We might argue in law that a trust is a contract. For example, when you look at a very advanced power of attorney, you might see that an advanced power of attorney says, my agent under the power of attorney can create a trust. Well, why is that? Because a trust basically is a contract. So that's a good way of thinking about it, but it's a relationship between a grantor. In the old days, this might have been called a donor or a trustor, but now the modern term is grantor, and a trustee. And this is for the benefit of a beneficiary. So the parameters, the roles, the responsibilities are described within that trust. Now, a good trust is going to describe all of that. Are there trusts that don't do a good job with that? And the answer is yes, and that's a little bit of a problem. But most trusts do a decent job, at least, of describing the basic trust parameters. Also, there is something called a letter of wishes that could be attached to a trust, and that might help a tremendous amount in describing what the grantor's intentions were. Now, who are the parties? Again, being redundant, the grantor, the settlor or trustor, the donor, those are the old terms. The grantor is the person establishing the trust. The trustee is the person who accepts the trust property and holds it in further trust for the benefit of a beneficiary as provided in the documents. Again, we want a trustee who understands this and who reads the trust. A beneficiary, of course, is a person who receives benefit from the trust according to its terms. We might argue today that a trust needs to be flexible. There's lots of mechanisms in the law to keep trusts flexible or to be able to flex otherwise inflexible provisions. But if we have these basic elements, we have a trust and the trustee knows what they're supposed to do, generally speaking. A revocable trust, as many of you know, it can be amended. It's revocable. It can be modified. It can be restated. It could even be revoked because it's a revocable trust. What is a revocable trust? It's a substitute for a will. So those of you who are on this webinar who don't know this basic terminology, do not feel bad. If you were a person coming to get an estate plan in place, you would either be putting a will-based plan in place or a trust-based plan. The revocable trust-based plan is nothing more than a substitute for a will. It's a will substitute for someone who wants to avoid probate. So the revocable trust is just a lifetime fancy will, as we might call it. It's obviously not a will, but that's a very old-fashioned way of thinking about it. An irrevocable trust is a trust either created at death. I died and I left a trust for someone, and that trust was obviously irrevocable at my passing. Or there could be a lifetime irrevocable trust, a charitable trust, a special needs trust, a life insurance trust. The way I would think about an irrevocable trust in a simple way of thinking is simply to say this: a revocable trust is a substitute for a will for someone who wants to avoid probate. An irrevocable trust, we might say, on a very broad scale, is a trust for a special purpose. It's either a trust at death or a trust during life for a special purpose. Common trusts. So again, the traditional revocable trust avoids probate if it is fully funded. So what are we talking about this for? Well, we're trying to give you a basic background of what a trustee's responsibility is. Let's say that I was a successor trustee to someone who became incapacitated and they had a revocable trust. Well, this is just a substitute for a will. What's my fiduciary duty? Well, the first thing I look at is this trust fully funded? Are the non-retirement assets in the trust and the retirement type assets outside the trust the way they're supposed to be with proper beneficiary designation? So here we might argue that even though this looks like a simple trust, my fiduciary responsibility is to make sure that trust gets funded because the grantor is still living. So this is nothing more than a substitute for a will. It's private, but it does not avoid taxes. It does not provide asset protection, but it does avoid probate if it is properly done, including on out-of-state property. There could be trusts for at-risk beneficiaries. Now, these are trusts that are generally irrevocable. Again, I had a relative. This person had issues, they needed to be protected from themselves. Or maybe I had a relative who was perfectly fine and responsible, but I just wanted to give them protection from creditors, potential creditors, bankruptcy, bad marriages. These trusts can be set up either during life or at death, and they can be set up in perpetuity, meaning forever. And that is something that is very commonly done. Those beneficiaries who don't have behavior issues or substance abuse issues or spendthrift issues, meaning they're spending all of their money, they can be in charge of their own trusts to some degree, and there are different designs for this. Now, remember that even though trusts at death or trusts during life for beneficiaries can be set up every day, the problem is that there are some exception creditors. So there's protection from most creditors in irrevocable trusts, but except for the state of Nevada, there are exception creditors such as child support, alimony, and Uncle Sam could still get in those trusts. But generally speaking, we can provide protection for beneficiaries, and in some cases, still give the beneficiary control over their own trust. Of course, there are special needs trusts. There are third-party trusts, which are the bread and butter supplemental needs trusts for parents and grandparents and relatives that are in use in normal estate planning, everyday estate planning. And then there are first-party trusts. These are trusts where the beneficiary was injured in an auto accident or a train accident or a birth injury, or they are receiving a structured settlement of some kind, or they received an inheritance they weren't supposed to receive. All of this background information is just to try to give you some foundation from which to think about, well, when I appoint a trustee, what should that person be thinking? What kind of person am I looking for? What are their responsibilities in these various roles? So again, a trustee is a person who accepts the trust property, is a fiduciary, and manages that property. A beneficiary is a person for whom the trust is to be provided for. How and when and what amounts can this person benefit from the trust, depending on whether it's a general needs trust, a trust for health, education, maintenance, and support, for example, for a healthy person, or a supplemental needs trust, a trust that is more discretionary under the Discretionary Trust Act. Let's talk about grantor versus non-grantor trusts. And Jeff, you stop me at any time. I think we're doing pretty well on time. It's 28 after the hour. For those of you who haven't had a second or third or fourth cup of coffee, I recommend that you grab that now. But in all seriousness, I'm only going to take about a minute on this. I want you to think about this simple concept and not make it more complicated than it is. This concept right here of what is a grantor trust and what is a non-grantor trust will drive you batty if you allow it. So I want you to think about this. A grantor trust is a trust where the grantor pays the income tax. A grantor trust is a trust where the grantor pays the income tax. Now, the basic form of a grantor trust is a revocable trust. You establish this will substitute. You put your assets in this trust to avoid probate. It's a wonderful estate planning tool. You pay all the taxes because that trust is identified by your Social Security number. That is the basic grantor trust. Your 1040 that you file every year does not change. Now, what makes this complicated is that there are irrevocable trusts that can be created as grantor trusts, such as a life insurance trust. You could create an irrevocable trust, which is what? A trust with a special purpose. For example, a life insurance trust. That trust can be a grantor trust, where whatever income is created, who pays the tax? The grantor. So think about a grantor trust, no matter whether it's irrevocable or revocable, the simple substitute for a will, the grantor pays the tax. A non-grantor trust is a trust where the trust pays the tax. A non-grantor trust is a trust where the trust pays the tax. A good example of this is someone passed away and left a trust for their child. This is an irrevocable trust. It has its own tax ID number. It pays its own tax. And trusts are taxed at a very high rate very quickly, but the trust has to be managed. You'll notice back in the beginning of the presentation, one of the duties of a trustee, as you think about who should be your trustee, one of the duties of that trustee is to manage the trust taxation, because trusts pay more tax than individuals unless it is properly managed. So grantor pays the tax in a grantor trust, trust pays the tax in a non-grantor trust, and that income tax has to be managed. Now, your fiduciary, your trustee, they have to be aware that Maryland now has a Maryland Trust Act since 2014. Maryland has done a lot of great things to get up to speed. I remember as a young lawyer, it always seemed like we were lagging behind in Maryland. Other states had more advanced laws. Well, in 2014, Maryland did a lot and got national recognition for really updating its Trust Act. So here are some of the provisions of the Trust Act. We want to make sure that whoever you're going to think about appointing, that this person has a good understanding. Qualified beneficiaries are now entitled to notice. A qualified beneficiary is an adult who's basically receiving distribution from a trust. Now, this has to be very clearly understood. Let's say that your trustee stepped into their role. They're a wonderful person, but they missed this. They did not get professional advice. They did not give notices, as you'll see on this slide, to qualified beneficiaries. Well, they just breached their duty. What is this all about? Well, prior to 2014, beneficiaries did not have a right to notice. They did not have a right to information once someone died with a trust. Well, that's hard to believe, but that was the law. People that are receiving distributions, or what we might call interested persons in an estate, are entitled to notice, but this wasn't true for trusts. So this is something we want your trustee to be aware of. Don't fall victim to just going it alone, wearing a very narrow vision glasses, so to speak, where you're not looking and getting advice, because you could fall victim to not providing the proper notices. Again, qualified beneficiaries have certain rights. Trustee must provide the following: a copy of the trust, annual reports, notices, reports of termination of a trustee. These notices have to go out. All right. So far, I hope I'm giving you some foundation, some broad scope of knowledge that you might not have had before. As you think inside of this bubble, of this vacuum that I'm creating, about who should step in there and be your trustee. How should you think about this? All right. Our financial advisor colleagues, some of them are extremely important to us because we work collaboratively with our financial advisor colleagues and referral partners to help clients establish the highest forms of relationships and results. So here, what do we have? Well, we have trustees doing what trustees are supposed to do, which is fiduciary duty. And that is working with our financial advisor colleagues, or again, the financial advisor to the trust in that example, to make sure that once the trust is established, there's plenty of cash, there's a checkbook. Should there be a debit card? I personally don't use those, but trustees can use those. How is the investment allocation to be made? Is the trust going to be funded with cash because the assets were sold? Are they going to be funded with in-kind assets that are coming over from another trust? When the person died, did the inherited assets get a stepped up basis to new fair market value? Working with the financial advisor in collaboration as a partner, because the trustee cannot and should not go it alone. Managing the portfolio. Is this portfolio geared towards the kind of goals that this trust has? Now remember, this person has a fiduciary responsibility to invest, and I'm talking in a very general sense. Certainly there are trusts that are concentrated in certain stocks, and this puts the trustee in a risk of breaching their fiduciary responsibility. But in a general sense, the trustee is going to be expected to invest as a prudent person would, and they need to ask the financial advisor, please provide me with what? An investment policy statement that says, I am doing my duty, you are doing your duty, because I am the trustee position of responsibility with these assets. So again, what are the ongoing cash needs? How should this be invested? I was talking to a financial advisor friend of mine who's been a wonderful collaborative partner all these years. He and I worked on a case several years ago through his firm with another wonderful advisor at that firm, where a trustee of a trust had for many, many years had the investments improperly allocated, considering what the mission or the purpose of the trust was. So this is something we want your trustee to understand. Their fiduciary responsibility in establishing and running this trust in coordination with a financial advisor. Now, Jeff, I don't know why we don't have these photos in here of the perfect person. You promised me we were going to get a photo of a perfect person, and maybe you just haven't found them yet. But when you do, Jeff, we're going to put that photo in here. And that perfect trustee is going to be the person who understands all of these things. Let's start with the right side on the bottom, these concentric circles. Remember, as we just discussed, the good trustee, the fiduciary person that is fiduciary-minded person, I should say, is the person who understands their responsibility about proper investments, understands basically taxes. They don't have to understand all of the black letter law about taxes, but what do? They avail themselves of professional help. I myself am a trustee on many trusts, and I was sitting the other day on a conference call with a CPA. And even though I wasn't necessarily matching wits with that CPA about some of the complex tax issues we were talking about, I understood the basics, and I was exercising my fiduciary duty of dealing with that CPA. So this is what we're really talking about here. The trustee is going to be accountable. They keep accurate records. They keep the beneficiary informed. They comply with their duties. And how do they know that? They avail themselves of legal advice, because a trust does have legal aspects. And up at the top, this could be a trust where we have at-risk beneficiaries or individuals with disabilities or of diminished capacity. This person may need advocacy. The trustee needs to understand public benefits, for example, in a special needs trust, and promote the independence of the person. Let's say the person has issues. They may be significant or marginal, but there are issues having to do with disability. Perhaps an advocate should be hired. Perhaps professionals should be hired in the community to support this person and promote their independence. So as we continue to go through on time, it's almost 20 till the hour. Why is trustee selection so important? Well, trusts can last forever. We mentioned that. There are trusts, they have different names. Some of them are called generation skipping trust, GST trust. There are trusts that are to last forever, and you might refer to them as a bloodline trust or a dynasty trust. These trusts can last forever, and Maryland has abolished the rule against perpetuities that would limit the time trusts can last. And most states, not all, but most states have abolished this. So trustee selection is important because trusts can last forever. Trusts are more portable than ever. You might have established a trust for a loved one here in Maryland or in the surrounding Delmarva area, but that child is now living in Colorado. What should the state law be? What should the situs be for that trust? States are in competition for trusts. States want to attract trust business and assets under management. Again, I just mentioned this, beneficiaries are likely to change their domicile. And trustees have options. What if you create a trust, you name trustees, you did a wonderful job, and that trustee now refuses to serve, or that trustee is not well, or that trustee wasn't doing a good job, and they were removed by a fiduciary that we're going to talk about here shortly called a trust protector. Trusts can be decanted. Trusts can be changed from this form to a completely different form, and Maryland has a wonderful decanting law now as of October of 2023. Circumstances change of all kinds: personal, health, political, family dynamics. So trustee selection is very important, but possibly one of the most important things is, as I mentioned here in this last bullet point, is building in flexibility. So as you think through your process, your mental checklist, this may be easy for you. You may have children or siblings or other relatives that will serve in the role of trustee. However, we want to think clearly now about that, because we want to ask ourselves, should interested persons like family members, should those people, or should there be independent trustees considered for that role? So there's a difference between an interested person and an independent person. The IRS defines this: interested persons, such as family members serving as trustees, versus independent persons. Now, it's beyond the scope of this discussion today, but independent trustees provide a level of asset protection that is typically greater than that of an interested trustee. So building in flexibility, even if we're going to name an interested trustee, where there could be an independent trustee if it was needed. This has to do with counseling. This has to do with deciding what is the goal, okay? So if you've been appointed or you're thinking about appointing someone, we want to ask ourselves, what is the estate planning goal, or what was the intention of the grantor when they created this trust with regard to protection of beneficiaries, flexibility for beneficiaries? All of this is this ambiguous discussion to some degree about independent versus interested trustees. I promise that if you engage in this discussion, you will have an epiphany eventually about what the clouds will clear. You'll have an idea of what you want to do with your trustee selection. Now, this is what we're getting to in the next bullet point. This is best done during document review. So in other words, if you're on this webinar today to think about your own trustee selection, which I assume most of you are, this is best done in review and counseling and discussion and diagrams and thinking about the risks and rewards and the fees. What is the cost of an independent trustee versus an interested trustee? Who should be a trust protector, which we're going to get into here in just a couple of bullet points? Should that trust protector be a family member, or should it be an independent person, or vice versa? Conflicts between interested trustees. This can be a problem that is pretty apparent to most people, that if we start mixing apples and oranges, people that might not get along because they're siblings, we're just asking for trouble, and that's going to be expensive. We're going to lose money. There's going to be litigation. There's going to be legal fees. There's going to be all kinds of waste, and it's going to be a problem. Let's not do that. And again, I just mentioned this: individual independent trustees. Who is a friend of yours? Who is a friend of your child that might be an outstanding individual that would make a great individual trustee? Or is that individual an attorney or a CPA or another professional who would serve as an independent trustee? So you see, it does not have to be a corporate trustee to be an independent trustee. But now the converse of that is, yes, a corporate trustee. Should this be a bank, trust company, or a servicing organization that services your brokerage firm and acts as a corporate trustee? Is it a credit union that has a corporate trustee relationship? So advantages and disadvantages. Well, sometimes this can take a long time to explain, so I'll try to keep this brief. The advantages of an individual independent trustee would be that the individual trustee might be someone that you have a lot of confidence in, and you don't want to deal with a corporate entity. The disadvantages would be that individual trustee, if they are not a professional, they haven't registered their fee schedule with the Secretary of State, they may not understand trust concepts, they may be busy, they may travel a lot. So that's a potential disadvantage. Now, an advantage would be, again, you avoid the corporate trustee relationship. You have more confidence in this person, whether it's a professional or a non-professional individual trustee, and you just have more peace of mind about it, so long as you have built in flexibility. Corporate independent trustees are going to be in great competition these days. That's been my experience, subject to the opinions of others on this webinar, that corporate trustees are vying for your business. They are driving prices down for trustee supervision of the trust. And so this is going to vary, but I think if you are interested in exploring corporate trustee relationships, you'll find that the fees are probably lower than I have ever seen. So we want to think in terms of a corporate trustee usually files the tax return for the trust. They do the management of the investments, but not always. That's not always true. There are corporate trustee relationships where you can use your own financial advisor to continue to be the face of the trust after your passing or during life if you create an irrevocable trust. But they are backed by a corporate trustee who is actually the self-directed trustee of the trust. Trust protector considerations. A trust protector is a special fiduciary. Maryland has honored the use of trust protectors in the law, called trust advisors actually, but called trust protectors more on a national level. And this is a special fiduciary who can do many different things if tasked by the grantor. But the typical basic duties are the power to remove and replace trustees or the power to amend the trust. So a trust protector adds scope, flexibility, and lots of wiggle room inside of a trust versus a trust that does not have that. So I strongly recommend the use of trust protectors, but they are not required. One of the things to remember as you learn more or think more about a trust protector is when you are making your trustee selection, you may be, still nervous about this. I've thought about it. I've done all my due diligence, but I'm just worried about this trustee issue. Remember, you can have a little bit more, in some cases, a lot more peace of mind if you name a trust protector who well, I've done my best to name these trustees, but I have peace of mind knowing two things. I'm going to keep my estate plan updated over the years. I'm not just going to set it and forget it. I'm going to update my estate plan. And when I do, I'm going to have more peace of mind about I can always update my trustees. I can always rethink that as throughout the rest of my life. But the second thing is that you've installed a trust protector provision that if a trustee needed to be replaced, if a trustee needed to be removed, they weren't doing a great job, or there needed to be a mediation because of a problem with the trustee, you've installed a trust protector that inserts that kind of flexibility into an otherwise inflexible kind of situation. Now, fortunately, in our world today, we have more flexibility in the law through the use of non-judicial settlement agreements and decanting and other things, judicial modification of trust. But I still think the trust protector is a basic fundamental flexibility tool that for most people should be included, again, although it's not required.
Hey there, Steve.
Hey, Jeff, do we have
Can
a
we
question?
pause for a few
Yeah.
questions here? Lots of great information here. First question, in the case of a trust established in my will for a minor grandchild, does the trustee's role begin only upon my death?
Thank you for that wonderful question. The answer would be yes, based on what you've said. You have a will-based plan, and that will-based plan creates a trust that is embedded in that will. We would call that a testamentary trust, and that trust is created upon your death, and that is when the fiduciary duty starts. Thank you for that.
Okay, next. My sole beneficiary is a, quote, charity, unquote. Do they receive the gift before or after taxes? And is there anything very important to know about having a charity as your beneficiary?
Well, thank you very much for that. I'm just going to have to make a few assumptions. That was a great question. My assumption is that when you pass away, that you either have assets coming from your will or trust directly to charity, and perhaps, I don't know for sure, you may have retirement assets, IRAs or 401ks, that are going straight to charity. So if you are leaving an outright distribution to charity from an IRA, which you may or may not be saying, that is the most powerful play, I would say, so to speak, in estate planning. The money goes from point A to point B. there is no taxation on that traditional IRA or 401k that would otherwise be taxable to an individual who would lose 30% of that. So that's powerful if that's what you're doing. If you're leaving non-retirement assets from your will or trust to a charity, that's a wonderful thing as well. So sometimes people leave trusts for charity. Sometimes there can be certain funds that advisors have for charitable distributions. It just depends on how complex you're making it. But if you're having a straightforward approach from a will to charity, from a revocable trust to charity, or from IRAs or 401ks to charity, that is going to be a wonderful thing and give you a charitable deduction. What I would discourage anyone from doing is if you are talking about IRA plans, as far as I'm just trying to say retirement plans, if you're talking about retirement plans and you want to keep it simple and powerful, I would go directly from a retirement plan straight to charity. I would not run the retirement plan through a will for sure, because that will become a probate asset and be distributed. It's subject to all the tax. And even if you run that IRA through a revocable trust, even though revocable trusts can avoid that problem, you're still risking taking a beautiful gift that was free of tax and causing potential taxation before it gets to the charity. So straight from IRAs or 401ks to charity, although there are different approaches for different people, that's a powerful approach. And non-retirement assets straight from a will or trust to charity, very powerful.
Steve, thank you. And one more. Can you explain what a W-9 is, and is it important for the beneficiary, or is it important at all?
Well, that's a great question. When you set up a trust account, oftentimes you'll be asked to provide a W-9. So this is just a verification of a tax ID number. And it has different applications when it's asked for, and I probably wouldn't be able to expound on all that, but it is important, especially if you're being asked to complete it, of course, by an advisory company or the trust, the company where the trust account is going to be set up.
Okay, thank you, Steve.
Thank you, Jeff. Okay, in the remaining time that we have, we talked about a little bit of the difference between interested trustees and independent trustees. So again, different standards of distribution. Now, I'm going to cause confusion here, and I don't want to. With an independent trustee, the standard of distribution can be different. And that means, by definition, it is different. And although we can't elaborate a lot of this morning, what this means is the beneficiary in a properly drafted trust is going to have much greater asset protection. If there's an interested trustee, such as the beneficiary themselves, as Maryland allows, there won't be as much asset protection and substantially less, generally speaking. But there will be what we might call a modicum of asset protection if there is a child or other interested person who is a trustee of a trust for someone. So independent versus interested, there's different standards of distribution, different points of view, different levels of objectivity. For example, if there is a corporate trustee or an independent person, they might have a different point of view than the interested person. Different levels of oversight, depending on whether it's a corporation or an individual who happens to be an attorney. There might be more oversight because of the professional experience, and different practical considerations such as fees and relationships and so forth. So all of this is a counseling issue. We talked about the trust protector. Now I'm going to be redundant, and this is on purpose. It's a special fiduciary. Is it required? No. Maryland had no trust protector prior to 2014, or what Maryland calls the trust advisor. And the trust advisor or trust protector was something that we at Elville and Associates always included in documents in prior years, prior to 2014, because on a national level, we knew that trust protectors provide real flexibility in trust. So this is a special fiduciary that is given certain specific powers. It's a basic power of amendment. The trust protector has the ability to direct a trustee to amend a trust, or to direct the amendment of a trust, because the trust protector's job, and this is subject to controversy, this is my opinion, The trust protector's job is to further the intention of the grantor. So if you leave a trust for someone and you have a specific purpose, in my opinion, the trust protector is a person who is to help perpetuate or enhance your vision of what your purpose was for that person in that trust. So this takes a little bit of getting used to. This takes a little bit of open-mindedness. I am actually going to appoint a third person who has power, tremendous power, and I'm giving it to them because I'm giving them flexibility. Well, most people come around to this idea and say, yes, I understand this and this is a good thing, but not everybody. So I would say most people will kind of get this idea in their minds, get their minds around it, and they will insert this kind of flexibility, but not everybody. It's not required, but I do recommend it. It's a power to remove and replace trustees. It's a power to direct a trustee. It can be a power to mediate disputes. It's a power of amendment. It's a power to compel accountings. And there are many other trust protectors' powers that can be provided. This is a question of trust design. Let's talk about the roles of trustees. Well, in wills, a person just nicely asked a question a moment ago and said that they had a will. Well, let's pretend that we have a will. Let's pretend we have a married person, and that married person dies and has a surviving spouse and left a trust for the survivor. Well, for purposes of this webinar, we're going to say that that person either left a marital trust for the benefit of the survivor, or they left a non-marital trust for the benefit of the survivor. And there are differences in those two trusts, but basically it's for the benefit of the survivor. Well, there needs to be a trustee of that trust. So that's an example of a trustee role. That could be the spouse, that could be the spouse and children, that could be an independent person. Another scenario, which was just discussed, which is a trust that was established for the benefit of a young person. So let's say somebody under 25 or 30 years old. That trust could be a testamentary irrevocable trust, which it would be, that has a spendthrift provision. It's protecting that beneficiary from creditors. So this trustee could be the beneficiary, but maybe that trustee should not be the beneficiary. Maybe it should be an independent person for greater asset protection. A trustee of an irrevocable spendthrift trust of another person. So let's say that that will created a trust for a niece who needed trust protection. Well, that's another example of a trust at death and a simple example of a role of a trustee. In a living trust, like a revocable trust, which is what? Nothing more than a substitute for a will, we have a little bit of the same, but a little bit different. Because now we have a trust, a grantor trust, which is a trust that the grantor pays the tax of the trust. But now this is a tool during the life of the grantor. So if the grantor became incapacitated, there would have to be a successor trustee. If the grantor dies, the trust has to be administered. There has to be a trustee. But everything else here is the same. That revocable trust created a trust for a young person. That trust could have been a spendthrift trust forever, protecting them from the claims of creditors. Or it could be a trust for another party where another person that's named as a trustee would be the trustee of that trust at death. So you see, these are similar roles of trustees in a will or in a trust. We talked a little bit about corporate trustees, experience, asset management. Some people are very committed to their broker-dealer and say, my broker-dealer, my investment advisor has a trustee relationship. I want to keep those assets under management. There. Corporate trustees are regulated by state and federal government. Typically, they are reliable. Typically, they have objectivity. Typically, they have lots of referral knowledge, institutional knowledge. Typically, they are in the game for the long term and provide peace of mind. With all this said, can anything happen today in today's world? The answer is yes. So for flexibility, we build in what? At least a trust protector who can make changes and deal with the trust as it lasts for a long time into the future in our changing world. What is successor trustee risk? It could be age and experience. This person that you named, you never kept up with the trust, you never amended your trust, you never kept up with your estate plan. You never modified it over time, which is a mistake. This person became ill, or this person did not demonstrate the types of experience that you needed that person to demonstrate. So that's a risk. Health, we talked about this, and deterioration. The trustee is typically not required to post a bond because that's just a huge waste of money in most circumstances. So here you have some risk because you're trusting that trustee, so to speak, to make sure they are handling the assets even though they are not insured by a bond. Other life changes, divorce, creditors, bankruptcy, the unforeseen things, disconnection with the needs of the beneficiary. Well, that's a big risk. You were depending on this trustee to advocate and keep accountings and keep information flowing to the beneficiary, but now they've become disconnected. The demands of the beneficiary. Now let's talk about this. A beneficiary could be so demanding that there is no trustee that is willing to serve. Now that's kind of out of your control. That may be shocking to some of you, but that can actually happen. It's very rare, but that can happen. But that's one of the risks. When you look at all of these things, last two things, willingness of the trustee, the fortitude of the trustee to persevere, even when they don't really want to. How can we deal with all of these things? By building in flexibility, for example, a trust protector, and making sure that you update your estate plan over time. Don't let it set stagnant like most people do for 18, 19, 20 years at a time. Trustee compensation is a bit of a successor trustee risk, and what I mean by that is there are different types of compensation. Your document, or the document that you're concerned about, is going to articulate whether it's statutory compensation, reasonable compensation, or if it's a corporate type trustee or independent professional, the compensation is going to be dictated by a fee schedule. Now we're almost on time, and I promised we would end on time, and we're pretty much on time. So I just wanted to say thank you for sitting through all of that. I did expound quite a bit today on some of my personal experiences, and thank you for those who asked questions. If you have questions, we want to provide you with a path forward. Remember, when you consult with an attorney about any of these issues, there's nothing to fear. It's all confidential. It's an attorney-client privilege when you consult, even if you don't become a client or engage the attorney. Bring your estate planning documents or the trust documents that you are concerned about. I would say over the last year, we have reviewed many trust documents from other states, from different parts of the state of Maryland and other surrounding states, because there are so many trusts and so many people have questions about how do I administer this trust? How do I go forward? If you don't have an advisory team, we are here to help you form one. If you only have one or two people of the advisory team, if you have a financial advisor, but you don't have a CPA, you don't have an attorney, we're here to help you, or if any of those roles are incomplete in your makeup. If you have questions about why you should even have an advisory team, we're here to talk to you about the pros and cons of this, but generally speaking, you should have this team. We want you to come with questions, so please take the time to put your questions together. But remember, even if you come without a list of questions, we're here to discuss, we're here to counsel. We have high-tech facilities here. We are committed to education, compassion, and also legal technical solutions at a very high level. But perhaps most importantly, we are here to give you some time to think, to get out of the busy world, and to really settle down into what is best for the long term. How do you get on a path forward to constant updating and recalibrating of your estate plan over the years, so that when you pass away, you've made the right decisions to the greatest extent possible, and you've built in flexibility. Or if you are fiduciary for another trust and not your own estate planning, how we can think through these issues and try to understand them, family dynamics, and many more issues. So Jeff, it's still a beautiful day out as far as I can see here in Columbia, Maryland. I'm going to turn it back to you. I thank everybody for taking more than an hour of your time this morning to tune in to our webinar series, and have a wonderful rest of the week.
Steve, I couldn't have said it any better myself.
Thank
Great
you, Jeff.
information, so valuable. Always one of my favorite presentations, as I'm sure it is for our attendees. So now would be a great time to get any final questions that you have in to Steve. And we do have one. So Steve, I'm going to pose it to you here. It says, I'm an elderly person whose moderate assets may or may not become greatly depleted by the end of my life. For example, by expenses for nursing home or other assistance. What is the cost or benefit consideration for setting up a trust in relation to that? In other words, if my estate is very depleted, how do I measure the cost of the independent trustee versus the size of the assets and the remaining estates?
Well, thank you for that very thoughtful question. I'm going to try to answer and maybe get some traction here on this answer. Thank you for being honest about what you're considering to be a depletion of your estate. It's difficult because the one constant I heard in your question is that you don't expect your estate to be completely depleted. So I think it's a question of cost-benefit analysis. What is your goal? I think we always want to talk about what is our estate planning goal, whether we have, maybe your goal has changed if your assets have gone down. So, or maybe it's the same as it was when your assets had not been quite so depleted. So we start with goal, G-O-A-L. What is my goal? Now, once we know what your goal is, we can do cost-benefit analysis. How do we accomplish that goal? Let's say it was a goal of protection or leaving assets in further trust. Well, now, what kind of asset protection are we trying to provide? Well, if it's high-level asset protection on a broad scale, we do want to use an independent trustee, for example. Now, what if we do want to use an independent trustee? Now, what are your relationships? What are your existing relationships? Are there independent trustee relationships that could be available that will actually agree to serve, even though your assets are depleted, in your opinion? And we'd have to see how much that is. And is it worth it on a cost basis analysis to leave assets in further trust where there's an independent trustee that's entitled to fees? Is there enough assets there to justify that? So I think it's a question of goals, then looking at the mechanics, looking at the cost benefit analysis, looking at the types of trustees that are available depending on your goal. We can rule out certain ones already that want huge amounts of assets under management from the get-go, and then the ones that would be willing to serve for lower amounts of assets, even at those compressed or competitive rates. Is it still worth it? And then we would come to some conclusions that you could either let go of this idea, or you could say, yes, this idea still has legs, even though I have a depleted estate at this point. So that's what, and lastly, whether those assets are retirement type plans or not, or non-retirement. So I think we would look at all of that and try to achieve peace of mind, and also give it the greatest chance possible to achieve whatever that goal might be.
Great, thank you, Steve. Last question for now is, where does an executor fit into today's discussion?
Thank you for that question. That's a wonderful question. Well, remember that as a person would approach a basic estate plan, if we're looking at a will, we know that wills by their very nature are subject to probate. Probate will require an executor, or what Maryland calls a personal representative. So a personal representative would administer the will after a person's death, pay all bills, be accountable to the Register of Wills, and so forth, and ultimately distribute the assets. So where the personal representative or executor comes into this discussion is that executor could be the same person who is named as a trustee. After they have distributed the estate, the trust is established, and that executor could be a trustee of that particular trust. So their fiduciary role just continues. Or that executor could be a person who's really not a trustee of a continuing trust, because remember that will, in my example, it provided for a continuing trust. So in that example, the executor could be just administering the estate and then ultimately distributing money to a trust where someone else is the trustee, or that executor could be administering an estate, establishing further trust, whether it's for a spouse or a non-spouse, and he or she himself or herself could be the trustee of that continuing trust. So that's the relationship, that the executor administers an estate, and then it's a question of whether that was their end of their role or whether they would continue as a trustee of further trusts.
Okay. Thank you, Steve. So those are all of our questions for now. A couple last things. I'll be sending out the video, which we've had many requests for, again, this afternoon, and also the slides as well. Also links to some recent presentations that are in relation to this presentation as well. That should be beneficial. Also, did you know that we have a YouTube channel that has every single webinar that we've ever done on it? So I'll be sending that link to you as well. We have a lot of subscribers, and anytime we have a presentation, it can feed right into your email if you choose. So that's a valuable resource for you as well. And also, as far as our upcoming schedule goes, on Friday the 30th at 10, we'll have planning for your future and using real estate as a vehicle with Main Street Home Loans mortgage advisor Marie Ritzenberg. And then on Wednesday, September 11th at 10 o'clock, learn what elder law attorneys are advising clients in 2024 with Steve. And then on the 18th, guardianship and the alternatives with Steve. On the 25th, the critical need to update your estate planning with Steve. And then for now, we have, last but not least, on the 27th, we'll be in person at Howard County Library, always one of our very favorite places to be, talking about the essentials of estate planning and elder law. And we will have an evening presentation in partnership with Timic Financial about estate planning as well, coming up at the end of September. I'll be sure to get that information to you. So lastly, thanks again to Steve for a great presentation. Just remember, it's not your job to know all of this information. That's why we're here, to be a resource to you at Elville and Associates in whatever capacity you see fit. So we're so thankful and appreciative for you being here today. Thank you to Steve, and we'll see you again soon on the Elville webinar series, and reach out to us with any questions. Take care and have a great day.